Can a joint bank account be garnished? Have you ever wondered what happens to your joint bank account if one spouse faces a financial issue? This is a common concern for couples managing their finances together. Let's break down how joint bank accounts can be affected by garnishment. Joint bank accounts can indeed be garnished, but the rules vary depending on where you live and the relationship between the account holders. For married couples, understanding these rules is essential for effective financial management. In community property states, debts incurred by one spouse during the marriage may be seen as shared. This means that if a creditor has a judgment against one spouse, they can often garnish funds from a joint account. In these states, marital assets, including joint accounts, are generally considered equally owned by both spouses. However, if the non-debtor spouse can prove that the funds in the account came solely from their income or assets, those funds may be protected. On the other hand, in common law or separate property states, creditors can only garnish the portion of the joint account that belongs to the debtor. For instance, if one spouse has a judgment against them, creditors might take up to half of the funds in the joint account, assuming both spouses have equal ownership. However, proving ownership percentages can be tricky. Without clear documentation, courts may assume equal ownership, which could lead to creditors freezing the entire account temporarily. For families, there are practical steps to consider. Keeping thorough records of deposits can help clarify which funds belong to the non-debtor spouse. This documentation can be crucial in recovering exempt amounts after a garnishment occurs. Additionally, maintaining separate accounts for individual expenses might provide some protection. However, in community property states, creditors may still access these accounts if marital funds are mixed together. It is also important to be aware of legal exemptions. Some states protect specific funds, like Social Security benefits, even if they are in joint accounts. However, proving this protection to the bank or court requires proactive steps. For married couples, understanding the risk of garnishment emphasizes the need to know your state's debt laws. Open communication about individual debts and seeking legal advice can help safeguard family finances. By being informed and prepared, couples can navigate the complexities of joint bank accounts and protect their shared assets effectively.